is supposed to be taking later on?
Well, first, Rob, yesterday in the Kimbrough and Gall decisions, the Supreme Court did something that pretty much nobody expected, and that was to really clarify exactly what the nature of the Sentencing Commission and the nature of the guidelines were supposed to be in terms of how judges utilize them. What the Supreme Court made very clear was that judges have discretion, and have not unfettered discretion, but much more discretion than they originally did when the guidelines were first promulgated back in 1987. And this discretion led even some of the justices to say, especially in the Kimbrough case, that the crack sentencing guidelines themselves, the court almost came out and said that they were per se unreasonable or irrational. And so this opens up a lot of opportunities for defendants that have been sentenced under the crack guidelines over the last several years, at least since the Booker case in 2005. In 2005, the Supreme Court ruled that the federal sentencing guidelines treated as mandatory were unconstitutional. They violated a defendant's Sixth Amendment rights. The Supreme Court there also did something unexpected. They kind of split the baby, and they created a remedial decision in that case stating that the guidelines were advisory. Really nobody knew what that meant, but yesterday they clarified what that meant, and that is, in plain English, that the guidelines simply are advisory. They're just one factor out of many federal judges to take into consideration when sentencing somebody.
Now, the U.S. Sentencing Commission will pick up the ball and do what?
Well, the U.S. Sentencing Commission also has been able to do something somewhat unprecedented. Whenever the Commission promulgates a guideline or amends a guideline, it first has to submit it to Congress for a period of 6 months. If Congress does nothing with that amendment, then it becomes effective as a guideline. This past May, the Commission submitted to Congress a revision to the crack sentencing guidelines and reduced the sentencing guidelines by 2 levels, which on average would affect somebody's sentence by around 2 years. That actually passed Congress. Congress did not act against that revision. The question now that's presented to the Commission in light of an enormous amount of coverage that this has received, especially from defense counsel and the judiciary, is whether or not to make these amendments to the crack sentencing guidelines retroactive. And that is what the Commission will be voting on, or maybe voting on, possibly maybe voting on this afternoon at about 3:30. But in light of yesterday's decisions in Kimbrough and Gall, it would seem that the Commission has a lot of opportunity to do the right thing, to make these amendments retroactive without having feared that there will be any type of judicial backlash.
Based on what was put out by the Supreme Court and your experience on the Sentencing Commission, do you expect that they will vote that way?
I fully expect that the Commission will vote to make the crack sentencing amendments retroactive. Whether it is they do it unanimously or not, I'm not sure, but most of us in the field feel that, especially after yesterday's cases in Kimbrough and Gall, that the Commission will vote to make these changes retroactive.
Now, making these changes retroactive will then do what?
Well, it will allow current offenders that are serving time for crack cocaine sentences to apply for resentencing under these new guidelines. It doesn't mean that there's going to be a flood of criminals and we're opening up the federal prisons for all these crack offenders to get out. According to Commission estimates, it'll affect approximately 20,000 offenders over the next several years, less than 2,000 for this first year. And it is not automatic. Just because one might be eligible for a retroactive application, it's still up to the particular judge, the sentencing judge, on whether to apply these new guidelines retroactively, or in other words, whether to, in fact, lower the sentence or not.
the same judge who sentenced them to the original
Generally
stretch?
speaking, if that judge is still on the bench, some of these offenders have been sitting in federal prison for quite some time, so there may be a new judge. But generally speaking, yes, the judge that originally sentenced them would be the one making the decision.
We're talking with Mark Allenbaugh, who's a former staff attorney with the U.S. Sentencing Commission, about crack cocaine sentencing guidelines, which are about to be changed based on decisions handed down by the Supreme Court in a vote expected later on today by the U.S. Sentencing Commission. If you'd like to get involved in this conversation, the numbers are there on the screen, 202-737-0001 for Republicans, 737-0002 for Democrats, and Independents, 202-628-0205. Our first call for Mark Allenbaugh comes from Mineral, Virginia, on our line for Independents.
Good morning.
Good morning.
Good morning. Go ahead.
Yes, I'd like to explain to you all that, first of all, I'm a sober user. I used to use drugs quite a bit when I was in high school and in the later years after high school, and I thankfully got away from them. But I'd like to tell you that, in my opinion, cocaine is probably one of the most insidious and evil drugs that I've ever run across in my lifetime. In all the years of different things I played around with, cocaine is way up there in terms of how it can destroy lives, families, people in general. But there's something I like the judges and the courts to think about. We've had a war against drugs going on for an awful long time, and we have failed at that war on drugs. I liken it to a parent that harshly punishes his child because the child is not obeying the parent. Our country is just slamming people in prisons as a cure for this problem that they cannot solve themselves. They can't stop these drugs from coming across our borders. Then they punish the users because of their failure to stop these hard drugs from coming across our borders. And the problems that all come along with the hard drugs that come across the borders. And as insane as this may sound, and it goes contrary to what I just spoke about, but this much I know about drug users is they're pretty lazy about getting their buzz on. And they're going to go to the easiest, most convenient place to get it, whether it's the ABC store for a bottle of booze or the ABC store for a pack of Acapulco Golds or Tijuana Thins or some homegrown marijuana. If they could go there and get that alcohol, which is a drug, by the way, everybody always separates alcohol from drugs, but alcohol is also a very insidious drug. I'm a sober alcoholic.
Okay, Mineral, can you make a point or ask a question regarding sentencing guidelines?
Sure. The question I like to ask is what is the government doing to take responsibility in their failure to stop these illegal drugs coming into our country?
Thanks for...
Well, I agree with the caller's statement that the war on drugs that the United States government has had since the mid-'80s has failed. And incarceration as a means of fighting that war on drugs has not worked at all. Our prison population has grown enormously since the war on drugs started. We have over 200,000 offenders currently just in the federal system alone. Over 2 million offenders in state and federal prisons across the United States. We incarcerate more people than any nation on earth. And a lot of that has to do with the war on drugs. What the government is doing about it, unfortunately, has been incarceration, has been the answer. Very little has been spent on rehabilitation or education. One of the problems that the Commission has recognized with the crack and powder cocaine sentencing disparity, for your viewers that may not know this, the crack cocaine is treated, or was treated 100 times more severely than powder cocaine. What that resulted in was a lot of the low-level crack users being incarcerated, where the intent of Congress originally was to try to hit the dealers and the drug wholesalers, not the low-level street dealers or, in many cases, the users. So certainly the policy has failed. The sentencing guidelines, certainly the mandatory minimums that Congress created, has also failed as a means of combating drugs.
And we've got a chart here from the USSG that talks about the race of drug offenders, which was also a critical component, I guess, of the decision made by the Supreme Court yesterday, and talking about the drug type and then the ethnicity of the people involved. And for powdered cocaine, they talked about 859 arrests, 14.7% for whites, 1,576 arrests, 27% for blacks, and for Hispanics 57%, others 1.2%. Then for crack cocaine, the numbers really get more, there's a bigger difference in the numbers. For whites, it's 9.3%. For blacks, 81%. Hispanics, 8.6%. And others, 1.1%. How much of this do you think went into the decision by the Supreme Court, and will that have an effect on the members of the Sentencing Commission?
Well, certainly those the sentencing statistics that you were referring to, I think, did come into play, certainly in the Kimbrough case yesterday. It wasn't too explicit, but it gave, it was cited by Justice Ginsburg in the Kimbrough case as an example of why a sentencing judge might think that the sentencing guidelines for crack cocaine, because of the racial disparity inherent in the way the sentencing guidelines are constructed, may create irrationality and may allow judges, or actually it would seem that judges now under the Kimbrough case would almost be forced to ignore the sentencing guidelines for crack cocaine because they were inherently irrational, given this racial disparity that is obvious in the sentencing statistics that you just cited, which are just from last year alone. If we went back over the last 10 years, it would shock people to see. And one other point, just quickly, too. One thing that's not captured in these statistics, that's not captured by the Sentencing Commission, that does impact on these statistics is prosecutorial discretion. In many districts, 5 grams of crack cocaine, let's say that you're in LA and you're Lindsay Lohan and you're caught with 5 grams of crack or 50 grams of powder cocaine in your car. The Central District of California is so busy with so many other cases involved, they may not have the resources to prosecute there. Whereas if the same case occurred in North Dakota or somewhere else, that case would get prosecuted. So there's a lot of work that the federal prosecutors do that isn't getting supervised, that does have an effect on sentencing statistics. When they choose to indict somebody, or whether they don't choose to indict somebody or give them a pass, can greatly affect a lot of these statistics too. So there may, not to sound conspiratorial, but there may be something in that, in prosecutorial discretion, that's reflected in these the sentencing statistics that we're seeing, where the racial disparity is so gross.
Our next call for Mark Allenbaugh comes from Charlotte, North Carolina.
Hi, I am Rebecca Gabriel, and I am very pleased with the outcome that happened yesterday, because the law is very biased. I'm not saying that we need to stop the war on drugs fight, because drugs is really bad in the black neighborhoods, but we need some kind of reform, and I think this is the time for reform. This is 2007. We're going into 2008, and I really think they need to make it retroactive.
Sir?
Well, I agree that this certainly is the time for reform, probably the best time in the Commission's 20-plus years in existence, given this, the recent Supreme Court precedent that has been moving in favor of giving judges more discretion, and now releasing the Commission from the strictures of Congress, at least to some degree, and Congress also changing in nature. I think we'll see more reform along the way. Hopefully this momentum will carry through with the new administration, and we will see if we're going to continue to use the terminology war on drugs, hopefully it could be a smarter war on drugs, and not just and not just an incarceration war.
Next up is Atlanta, Georgia, on our line for Republicans. Go ahead.
Yes, first I would like to thank you, C-SPAN, for this opportunity because I'm a 29-year-old black woman and I'm a conservative because I believe in the truth. And I appreciate you reading that article about the statistics that young black men are being incarcerated because of this war on drugs. Well, you've already answered my question, but what I really about how likely is that these people will be sentenced. What took so long is my question, basically. 87, it's 2007. What has taken our law so long to change for these people to fight the real war on drugs, like the first caller was saying before me? Thank you.
Well, unfortunately, federal prisoners do not make a very strong constituency, and legislators do not want to be seen as soft on crime. There are members of Congress that every year will bring up bills to reduce or change or eliminate the mandatory minimum sentences. Many have lobbied the Commission to change or reduce the sentencing guidelines, but it ultimately comes down to a political issue. And again, the constituents that are most concerned about this are federal offenders who lose the right to vote. And so that once you're convicted of a felony, in most jurisdictions you no longer have a right to vote. You're not going to matter to your local congressperson or your senator. But that's why it has taken so long. But luckily for us, even though it's taken long, better late than never, as they say, now is a great opportunity for the Commission, for Congress, and the Supreme Court to take a new look, a fresh perspective at federal sentencing.
We're talking about the crack cocaine sentencing guidelines with Mark Allenbaugh, who's a former staff attorney with the U.S. Sentencing Commission. He is now currently a managing partner of Allenbaugh Samini Law Firm with offices in Newport Beach, California, and Guangzhou, China. Back to the phones and Burlington, Vermont, on our line for Independence. You're on the Washington Journal. Thanks for waiting.
Yes, thank you. And I really appreciate you folks taking responsibility for, the arbitrariness of the federal sentencing guidelines. My question for you is, how do we recuperate? How do we help black men recuperate from this mistake?
That's a very difficult question to answer. Very often the damage has already been done when a defendant, and I have clients of mine that have been sentenced to many years in prison during the primes of their lives, to get out, to be sentenced to 10 or 20 years in prison, get out as a 40 or 50-year-old man and not have the ability to make a living. It's very difficult to fix that. The issue, unfortunately, doesn't lend itself to fixing the past, but what we can do about going forward in the future. Focusing again more on rehabilitation, more on educational programs in our federal system, which is, by the way, is 34% over capacity right now. Building better facilities, more humane facilities, taking a note from the rest of the world on how they treat their offenders. And certainly, just for example, we make up 5% of the world's population, but 20% of the world's prison population is here in the land of the free and the home of the brave. So I think we need to start looking elsewhere, taking notes from the Europeans and other countries.
What exactly is the U.S. Sentencing Commission?
The U.S. Sentencing Commission is a unique agency. It's an independent agency within the judicial branch of government. Most people are accustomed to agencies within the executive branch, such as the EPA or the IRS. And those agencies will create regulations that essentially have the force and effect of law. What Congress decided to do back in 1984, when they created the Sentencing Commission, was to create an expert agency, not within the executive branch, but within the judicial branch, to regulate judicial sentencing. And it was nominatively a apolitical branch, or an apolitical agency, where the politics that we've all grown to learn about when it comes to sentencing would not play a significant factor in how sentences were promulgated, or sentencing guidelines were promulgated, that it would be very empirically based. Now, to the Sentencing Commission's credit, or what the Sentencing Commission does, by and large, is collect data and performs hearings across the country on what sentences and what sentencing ranges are appropriate for particular crimes. And Congress every year creates new crimes that requires the Sentencing Commission to create new guidelines to apply to those particular crimes. But sometimes the Congress gets too involved in the Sentencing Commission and will hand down from on high directives that are very politically motivated and tells the Commission to do this and do that. So it kind of usurps the apolitical nature of the Sentencing Commission, and perhaps the biggest issue, or the biggest problem that we have seen over the years in terms of political interference by Congress with the Sentencing Commission has been mandatory minimums. That's something that many people tend to confuse. Mandatory minimum sentences and the federal sentencing guidelines are completely separate animals, completely separate systems. The federal sentencing guidelines map onto the mandatory minimums, but the federal sentencing guidelines would not look the way they do but for the fact that Congress also created the mandatory minimums at the same time they created the Commission. And that's something the Commission and many others have lobbied long and hard to get rid of, those mandatory minimum sentences.
Bellingham, Washington, go ahead.
Hi, yeah, I was wondering, is this going to affect, well, first of all, has the court changed? Are they going to start looking at drug laws differently now? And will this kind of decision also affect marijuana and other drugs? And also, is medical marijuana going to be changed, the laws toward medical marijuana? And if I may say one more thing, your last guest was unaware of the fact that the new move toward taking care of the poppies in Afghanistan is selling the opium to the pharmaceutical companies.
Thanks for your call.
Well, certainly the court has changed. We have 2 new justices recently, and that has certainly changed the nature of the court and how they view the sentencing guidelines. I think I speak for many in the defense community that yesterday's decisions, the 7-2 decisions, were quite surprising. We're more accustomed when it comes to sentencing issues, 5-4 decisions with many concurrences and many dissents, etc. And that wasn't the case here. With respect to medical marijuana, well, with respect to all drugs, certainly yesterday's decisions will affect not just drug sentences, but sentences across the board, given that the sentencing guidelines are now advisory. With respect to medical marijuana, that's a state-federal issue and not very pertinent to the sentencing guidelines.
What do you say to critics of yesterday's decision who say that this sends a wrong message and that maybe instead of softening the punishment for crack cocaine, that we stiffen the punishment for powdered cocaine?
Well, again, that's the old knee-jerk incarceration reaction. You know, let's just get tougher on punishment. If we increase the punishment for powder cocaine, you know, what good does it do? What is the point of incarceration? Is cocaine that overnight has become that dangerous of a drug? Are these offenders that dangerous? I mean, what has changed? There's really no rational reason, at least that I can see, why one would want to raise the penalties for cocaine and just increase incarceration rates in an already overcrowded federal system.
Our next call for Mark Allenbaugh comes from Waldorf, Maryland, on our line for Republicans.
Yes, good morning. Thanks for taking my call. You actually just asked the question that I had. I really didn't understand the reason for softening the penalty for crack cocaine and decreasing the penalty for crack versus increasing the penalty for powder. But I do understand your point as far as incarceration. But, you know, to me, the bottom line is this: don't sell drugs, you won't get locked up. And in my opinion, you're right. I guess our prison system definitely is not helping people out. So what is the cure to help get these drugs off the street? Thank you.
Sorry, I didn't quite catch the end of that.
The last part was, what is the cure for getting the drugs off the street?
Well, certainly education, community opportunities, jobs, very often the reason why people enter into the drug trade is they have no other opportunities. At least that's been in my personal experience with some of the persons that I've represented. That certainly would be the answer. Locking them up for a significant period of their lives in a prison system that teaches them to become better drug dealers certainly is not the answer and certainly will not help.
Our last call for Mark Allenbaugh comes from Wabasha, Minnesota.
Good morning, gentlemen. Thank you, Mr. Allenbaugh, for your efforts in this area. I first of all want to make a comment to reinforce the opinions of those who think that this war on drugs, like the war on terror, are a misuse of semantics and represent great, big, steaming piles of crap. As far as I'm concerned, the war on drugs is a make-work program for bureaucrats and for cops who should be better using their time corralling those folks who hit us over the heads and steal our property. But my question is involving the opinions of the minority here. First, give me a very concise review of the opinion of the majority, and then give me a look at the reasoning of the minority, those two ultra-right, bonehead, evil persons, Thomas and Alito. Thank you very much.
Quickly, yes. In the Kimbrough case, essentially the majority just reinforced and clarified prior precedent when they said that advisory guidelines are advisory. Both in Kimbrough and Gall, the judge is left to basically his or her discretion whether to follow the guidelines or not. There's no presumption that the guidelines are the correct sentence. The judge can take many factors into consideration, the guidelines just being one. The dissent, Thomas's dissent in Kimbrough, what he spoke to was more going back to his original dissent in the Booker case. In Booker, that was the 2005 Supreme Court opinion that held that the federal sentencing guidelines were merely advisory. He just disagreed and continues to disagree that that the majority in that case in Booker made the guidelines advisory. He would rather see, and quite frankly, I can't disagree with him too much on this, he would rather see a system where every factor that affects a sentence, that can increase a defendant's sentence, must be found by a jury beyond a reasonable doubt. That is his opinion, and he still continues to hold that opinion. That's why he dissented yesterday.
Mark Allenbaugh, thank you very much for being on the program.
Well, thank you. I appreciate it.
In just a few minutes, we're going to be looking at a new survey of U.S.-China relations with the survey's co-chairman, Chen Li. But first, we want to check back in at the hotline with Editor-in-Chief Amy Walter for another